This, is he required to make a decision now or not?
No, he's not here, Judge Brooks.
They took my guy back to the jail.
All right, we call two cases, the state of Texas versus Lace Christian, in cause numbers 22-40354 and 22-41222. Those cases were set for trial. We were about to pick a jury, and then the parties have renegotiated, and I believe the defendant is going to be pleading to 22-40354.
Yes, Judge.
And 22-41222 shall be dismissed pursuant to section 12.45 of the Texas Penal Code, which in summary provides that a person may, with the consent of the attorney for the state, admit during the sentencing hearing her guilt of one or more unadjudicated offenses and request the court to take each into account in determining sentence for the offense or offenses of which she stands adjudged guilty, which would have been 40354. Before court may take into account an admitted offense over which exclusive venue lies in another county or district, that won't apply in this case.
That's correct.
And I don't think part C is going to be applicable.
Oh, yeah.
Reducing something to a misdemeanor. All right, in 22-40354, the defendant Lace Christian, that is you.
Yes.
And you were here with Mr. Gerd.
This right here is a quiet power move. The state is invoking a provision that allows one serious charge to be dismissed, but not forgotten. Instead, it gets folded into sentencing on the remaining case. Translation? The defendant avoids a second conviction, but the judge still gets to consider everything when deciding punishment. It's a calculated trade. Fewer convictions on paper, but not necessarily less prison time.
Your attorney and the state's attorney, does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
She does and we can't just.
In summary, this indictment alleges that on or about May 10th, 2022 in Jefferson County, Texas, you committed the first-degree felony of murder by shooting the complainant with a deadly weapon, namely a firearm. Do you understand what you were charged with here?
Yes, sir.
This is a first-degree felony, which carries with it, if convicted, no less than 5 nor more than 99 years confinement imprisonment or life imprisonment, and a fine up to $10,000 can be assessed as well. Do you understand the punishment range? An agreement has been reached, I believe, between the parties that the defendant would be pleading guilty. And can you read it into the record, Mr. Gertz?
Yes, Judge. The agreement is for a cap.
It's okay. I just.
Thanks.
The agreement is for a cap of 40 years
Okay.
on this offense. It also has two subparts. The court will run this sentence concurrently with the sentence that were imposed this morning for the older sexual offenses, and that the court will grant a dismissal of the other pending murder case under or pursuant to an agreement under 1245.
All right, I'm going to change this, what looks like a 6 to a 0 on the 40. And bear with me, but you have to do an awkward maneuver just to erase anything there.
I also find I have to do awkward maneuvers when I'm writing.
Do you understand what you're charged with here, man?
Yes, yes, sir.
An agreement has been reached where you would be pleading guilty, and whatever sentence shall not exceed a cap of 40 years in prison to run concurrently with other cases. That means you were looking at no less than 5 nor more than 40 years confinement in prison.
Yes, sir.
And two other cases, 41222 will be dismissed as it will be taken into account under Section 1245, Texas Penal Code. And we will order a post-sentence, a pre-sentence report, a post-hearing report, pre-sentence report. We will return back, and all parties will get an opportunity to be heard, and then the court will make its decision. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement,
Let's pause here, because this is a point of no return. Once the judge confirms a punishment range and the defendant says yes, the exit doors start closing fast. By pleading guilty under a cap, she's gambling that the judge won't go anywhere near the top. And remember, once this plea is accepted, the right to appeal is basically gone. This is not a rehearsal. This is a real thing.
you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily?
Yes.
Understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence without objection.
We have no objection.
Admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you, or you've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true, it states. So help you God.
Yes, sir.
State's Exhibit 1 is part of the record for all purposes. We're going to order a pre-sentence report. We will return back
March 30th.
March 30th, 2026. All parties will have a chance to add information. The court will make its decision at that time, and then all other cases will be resolved
Yes, Judge.
if everything works.
Thank
You
you.
understand what has happened today, man?
Yes, sir.
Okay, thank you.
Yes, sir.
Okay, that one has been, here's this one, that one's been taken care of, so those two rather, other ones, at least tentatively.
Thank you.
That means we are back to trial, that we will bring the jury back tomorrow and choose. And Kimler, Mr. Kimler, what did y'all resolve? Come on up.
You're not right now, we released to head out of the jail.
Yeah, you're up next.
I know.
Okay, and we're gonna call some others in the event that fails. We'll see you in the morning.
Hands in the court as soon as I'm.
See you in the morning. Thank you. Right there. Thank you.
No, I'm not mad at you.
I am.
Yeah,
Yeah, I am.
I'm just jealous.
I am. This asbestos story makes me sick in my stomach, but of all those people who you injured.
Just about this, yeah.
No, it's impossible. That's what I do. I've been watching Epstein stuff all weekend.
Yeah. Well, don't watch it. Listen, it's bad.
That's last thing. These people looking at it.
I read it. It's true. Well,
Yeah.
We now
I
call,
don't disagree with that statement. I'll get you there.
we can now call 23 CR 1656, the state of Texas versus Carl Chopin. That is you with Mr. Stand by. With Mr. Kimber, your attorney and the state's attorney does the defendant waive a formal reading of this indictment and arraignment here. Can we proceed in sum?
Yes.
In summary, Mr. Chopin, this indictment alleges that on or about October 1st, 2023 in Jefferson County, Texas, you committed a second-degree felony of aggravated assault with a deadly weapon by striking the victim about the head and body with your hands and feet. And that caused bodily injury. And used or exhibited a deadly weapon, namely a firearm, during the commission of the assault. Do you understand what you're charged with there? Yes, sir.
He would
Stand
be,
by. I need a-
just for clarification,
Y'all are working on something.
he would be the party to a firearm, because I don't think he actually had the firearm, it brings a party.
That's correct.
A party that somebody else uses it, but you're responsible.
Yes.
Check it real quick.
This is a second degree felony, which means if convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range, sir?
Yes, sir.
An agreement's been reached where you would be pleading guilty, whatever sentence shall not, it's a confinement in a flat term of 5 years in prison. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge? Guilty or not guilty?
Yes.
Are you pleading guilty voluntarily? And because you are guilty?
Yes, sir.
I'm going to show you what's marked as Oath Exhibit 1. Did you sign that document voluntarily? Did you understand it? Discuss it with your attorney?
Yes, sir.
Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
Subject.
Without objection, it's submitted. Among other things, the states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
All right. State's Exhibit 1 made a part of the record for all purposes. I just want to read something into the record so it's clear because it sounds like there's an issue. A person is criminally responsible as a party to an offense if the offense is committed by his own conduct, by the conduct of another for which he is criminally responsible, or by both. Each party to an offense may be charged with the commission of the offense. Do you understand? And I think that's, somebody else may have been involved with this and acted as well. But if you are working with them, assisting them in any way, you become culpable as well, even though they may even be doing even worse actions than you are.
Yes,
But if you took part in it, then you become responsible as well. Do you understand?
Yes, sir.
So understanding all of this, are you admitting to being culpable or responsible through the law of parties in the commission of this offense?
Yes, sir.
All right.
That would particularly apply to the affirmative action. As far as his responsibility as a party for the use or exhibition of a deadly weapon.
Namely the firearm.
Correct.
All right. Anything else to add? All right. If nothing further, you plead guilty, this voluntarily, knowingly, intelligently, and State's Exhibit 1 is made a part of the record. If nothing further, I'm going to find you are mentally competent to enter your guilty plea. It is freely and voluntarily made. You know and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find.
This explanation from a judge is doing a lot of heavy lifting. In plain terms, you don't have to be the one who pulls the trigger to be guilty. If you assist, encourage, or participate in any meaningful way, the law treats you as just as responsible. That's why the judge is slowing things down here. He needs the record crystal clear that this plea covers responsibility as a participant, not just an observer.
You guilty beyond a reasonable doubt, and I now find you guilty beyond a reasonable doubt of this second-degree felony of aggravated assault with a deadly weapon, namely a firearm, in this cause number 23CR1656. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. You will be given credit for all time you have served in accordance with this case. Also, an affirmative finding that a deadly weapon, namely a firearm, was used during the commission of this assault, this offense, will be affirmatively applied to the judgment in this case of aggravated assault with a deadly weapon. Do you understand what has happened today, sir?
Yes, sir.
Anything else?
We rest.
Defense state, we are in recess on this. Thank you.
Yeah, I've been stuck. I don't want to go on that.
Okay. All right, we are in recess on this. I'll go talk to the jury and tell them to come back tomorrow.
We need to figure out what's going on.
Okay. Well, let's get
Let's get lined up.
let's rally all the troops we can
Since I didn't see all this coming this morning.
I know.
But.
Okay, so we've got,
Yes.
well, the second one was Gertz with Patel, and that pled. And then we had Bruce Smith with Aaron Tyler, and here's what we're gonna do is